Hello and welcome to our podcast. My name is Abbie Coleman and I'm an associate within Collier Bristow's commercial disputes team.
And my name is Tami Davis and I'm also an associate within the commercial disputes team.
So today, Tabby and I are talking about alternative dispute resolution, ADR for short, within the litigation space. So in this podcast, we'll be looking at the common types of ADR, the pros and cons of it, the court's approach to ADR, and some practical tips. And a good place, I think, to start would be to explain what ADR actually is.
Absolutely. So ADR is a means of resolving disputes outside of the traditional litigation court procedure. It can take place at any time, whether that's before court proceedings have been commenced or at the same time. And in our experience, about 70% of cases settled before trial. So ADR is something that everyone should always be considering, and it's also heavily encouraged by the courts, which we'll discuss later on in this podcast.
Exactly. I think we've both even seen a case settled from ADR at the trial itself or right before, so it's certainly never too late to be thinking about settlement. Now, there are lots of different types of ADR, but the most common ones that we'll be covering in this podcast are arbitration, mediation, and general negotiation. So if I take arbitration first, this is a private dispute resolution process where a neutral arbitrator or a tribunal of arbitrators act like a judge, hearing both sides and issuing a binding decision outside of the courtroom. There are statements of case in arbitrations, they're called a request and answer, and there are usually directions for disclosure and witness statements, just as there would be in court proceedings. But it's a much more flexible procedure which can be adapted to suit the case. Now, there are numerous arbitration centres available all around the world. And if there is an arbitration clause in your contract, you usually expect to see a certain centre and jurisdiction. So, for example, we might have the LCIA in London identified in that clause. There is also the option for an expedited arbitration, which can mean a decision is given as soon as within 6 months of the case management conference.
Abbie, you mentioned that arbitration clauses can be included within contracts. Why might parties do that?
So by including an arbitration clause, and those are clauses which mandate that any dispute relating to or arising out of the contract must be dealt with the arbitration rather than the court, you have a certain amount of control over the process. So often parties will do this for privacy reasons, as an arbitration would be confidential, whereas court proceedings are public. But even without having such a clause in your contract, parties might opt for arbitration because it's generally faster and more flexible than court proceedings. So, for example, parties can choose their arbitrator and the process, whereas court litigation follows strict procedural rules and is handled by an allocated judge within the judicial system. But the one thing I would say is that as arbitration rules have developed and become more complex, that gap between arbitration and court proceedings with regard to the speed and cost of the process is narrowing. So I think the biggest benefit of arbitration remains the fact that it's confidential rather than being within the public domain as court proceedings would be.
Well, it's certainly been interesting to see how arbitration's developed both here and in other jurisdictions. And more detail can be saved for another podcast on that. So turning to another form of ADR now, mediation. This is also a confidential process, but it's led by a mediator, which differs from an arbitrator in a few ways. So firstly, unlike an arbitrator, a mediator cannot impose a decision. Rather, they try to help facilitate settlement by encouraging open discussions and trying to guide the parties to narrow issues in dispute and reach a settlement. They don't take a side and they don't impose their views. If a settlement agreement is reached at a mediation, then that's usually documented in a legally binding contract referred to as a settlement agreement. And in our experience, mediations are very practical ways of resolving disputes. They typically last around a day and parties have control over the location, remoteness and timing. I've definitely done a few remote mediations and they can be helpful when the parties are based in different locations, especially if they're in different jurisdictions.
So why is mediation so common? I think we've seen a lot of commercial contracts that included a dispute resolution clause, which mandates that before either party can issue a claim, they have to at least try and mediate first. And there are plenty of parties who elect to mediate even without it being mandated by their contracts. So what is the appeal of mediation?
I think primarily mediations are quick and they're far less expensive than litigation and arbitration. It's often seen as a commercial decision in that parties want to try to avoid incurring the substantial fees of court proceedings. You also aren't limited to certain rules or required to get to the bottom of complex legal arguments. So it's far more of a commercial option. And as I've mentioned, mediation can take place at any time. So if the litigation's already started, the parties might consider staying those proceedings while they try to mediate. We've mentioned confidentiality a lot as a benefit of ADR, and mediations are covered by something called mediation privilege, which means that anything said during a mediation can't be repeated in open court. And that confidentiality confidentiality can help preserve business relationships and reputations. Sometimes, particularly with bigger corporations, the avoidance of reputational damage is a really important consideration. And also, crucially, mediations have a really high success rate. I think the latest statistics published by CEDA report a success rate of 87%.
Yeah, that's very promising success rate. So finally, we should mention just the good old-fashioned without prejudice negotiations. Parties can meet, speak on the phone, or correspond in writing on a without prejudice basis in an attempt to reach settlement. Now, there are two main types of without prejudice negotiations, one being Calderbank offers and the other being Part 36 offers. So a Calderbank offer is a general without prejudice offer, which is more flexible and allows the parties to choose their own terms, whereas a Part 36 offer is prescribed by the CPR and has strict requirements and complex automatic cost consequences if not accepted. Now, the main advantages of negotiations as a settlement strategy, rather than something more formal like a mediation or arbitration, is flexibility, speed, and control. Parties can tailor their discussions to their needs and avoid procedures and fees. And if those negotiations are without prejudice, that also means they're confidential and not put before the court until decision is made at trial. There's no third-party involvement, which can make this a cheaper and more straightforward way to settle a dispute.
Thanks, Abbie. So we've spoken about the three main types of ADR and the benefits of them. So probably now we can move on to practical tips. And I think the first consideration is timing and when to consider ADR.
Yeah, so it's very common for us to consider ADR prior to and then between kind of the big stages in litigation. So timing, as you say, is very much a strategic decision and it can be informed by a number of factors. There's certainly no one-size-fits-all rule on timing. For example, if you received a letter for action regarding matters that could be harmful to your reputation or the reputation of your company, regardless of whether you're confident about defending the allegations during court proceedings, you might wish to steer the other party towards ADR in whichever form so as to keep the issues out of the public domain.
And the merits of your case and your opponent's case is also a factor. So after statements of case have been exchanged, you'll have a better understanding of everyone's position and their respective merits. And so that can be a good juncture to consider ADR. And particularly with costs being a factor, as the next stages in litigation, like disclosure and witness statements, they're very time-consuming and costly. Your confidence in what disclosure will produce may also influence whether you're willing to engage in ADR before or after that stage of litigation, with, again, costs being a factor. And I think linked to that, we should really mention recoverability. If you're pursuing a defendant who has limited resources to enforce judgment against, then it's important to be mindful of that when balancing the progression of litigation and settlement negotiations. Do you want to incur another tranche of legal fees? Well, if they're not proportionate to the sums you'd be able to recover, then probably not. And, as Abbie said, there's no time limits to ADR and there's no restriction to how many times you can try it. It's very common in our experience to have regular without prejudice discussions throughout proceedings, and you can even try to mediate more than once.
No, absolutely. And I think as you touched on earlier, it's also really important to be mindful of the court's approach to ADR. So it's generally well known that the courts have strongly encouraged parties to engage in ADR and that failure to do so can have cost consequences if a case does proceed to trial. The pre-action protocol emphasises that litigation should be a last resort and the parties should consider whether negotiation or some other form of ADR might enable them to settle their dispute. Now, in the 2023 case of James Churchill versus MT County Borough Council, the Court of Appeal confirmed that the courts can, in appropriate circumstances, order the parties to participate in ADR. The CPR rules have also subsequently been amended to reflect this move towards mandatory ADR. So picking out a few examples, the overriding objective in CPR Section 1 now includes promoting or using alternative dispute resolution. The court's case management powers under CPR Section 3 now expressly includes the phrase ordering the parties to engage in alternative dispute resolution. And another one to mention is CPR Section 44, which now states that a court can consider whether a party acted unreasonably in refusing to engage in ADR when deciding on costs. So what that means is that even if you are successful at trial, if you have unreasonably failed to engage in ADR, settle the case, that could still have cost implications and could reduce the costs that are awarded to you. So it's definitely worth bearing in mind.
And so even setting aside the clear benefits of ADR, the strong likelihood of judicial disapproval for failing to at least attempt it makes ADR something that should seriously be considered.
Exactly. So that concludes our very brief overview of ADR in litigation. We've looked at what ADR is, when you might consider using it, the types of ADR available, and their pros and cons. So we hope that that's been helpful.
And Abbie and I will be working on creating a podcast episode on other, perhaps less common means of ADRs, like expert determination. So if this is an area of interest for you, do subscribe and stay in touch. And as always, if you require legal advice in relation to any of the topics in this podcast, please don't hesitate to contact our team here at Colley Bristow. Thank you for listening.